Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Professor Kavita Solanki at University School of Law and Legal Studies, Guru Gobind Singh, Indraprastha University, Delhi, Dwarka. Today we will start lecture number 2, which is Employee Compensation Act 1923. When we talk about the relevance of this act, it is a social security legislation. It has been passed with this intention to impose the responsibility upon the employer. Say if in case of any kind of the injury has been caused, then in that case, that would be the responsibility of the employer to take care of the cost of the injury. And here under this act, when we talk about, but this kind of the injury has to be caused in the course of employment and out of course of employment. Here we are talking about this is the utmost responsibility of the employer to bear this kind of the expenses. Neither into the law of torts this kind of the provisions has been made, or nor under any other kind of the social security legislation where we are trying to avoid the hardship. So under this act, we are talking about occupational disease, employer's liability, when the employer would be liable to give the compensation, and this act has been passed with the objective just to avoid the hardship and for the speedy disposal of the cases. Into this act, we will talk about amount of the compensation. So how the amount of the compensation can be given and whom the amount of the compensation can be given, and we will talk about how the distribution can be made. We are having the system for the review, we are having the authority who would be deciding all these cases, we are having the commissioner for this, and the schedules, 4 schedules has been given under this act. So we will talk about all these schedules. Either it is a case of total disablement, occupational disease, definition of the employee, because into this act now the definition has been amended, and it is a broad definition. I mean, more category of the workers has been included under this act, and we are having the amount of the compensation. So we are having the one of the schedule will talk about how the amount of the compensation can be measured. So we are having the formula has been given under this act. So this is very good legislation. So and the intent is just to speedy disposal of the cases, and so just to give the social security benefit to the workers. Employee Compensation Act is a social welfare legislation, and it has been enacted with a view to provide the compensation in case of the personal injury has been caused by the accident and certain occupation disease which has been arising and in the course of the employment and resulting into the disablement, or it is a case of the death. So this is basically based upon the principle of the employer's liability. Applicability of this act is, this act extends to the whole of India, and it passed on the first day of the July 1924. This act, it imposes a statutory responsibility of the employer, and here it is a moral obligation also of the employer towards the employee when they suffer from the physical disability or disease during the course of the employment in hazardous working conditions. So the object of this act is, the aim of this act is to provide the quick and the cheaper disposal of disputes relating to the compensation, which is not possible in comparison with the proceedings of the civil law. So, and under this act, we are having, if any kind of the dispute arises, we are having the definition of the dependent is given. So when we talk about under this act has been amended in 2010. Earlier we were talking about the definition of the worker, but nowadays we are using the term, amendment has been made and we are using the term employee here under this act. The intention is, the Second Labour Law Commission gave the recommendation just to use the word employee. The intention is just to take care of the gender neutrality, and into that amendment in 2010, again the definition of the employee has been broadened. So into the schedule 2, this definition, now we are having the more category of the employees into that category. So with this intention, this amendment has been made, and this act consists of 4 chapters, 36 sections and 4 schedules. Schedule 1, into which the list of the injuries has been given and deemed to result in a permanent total disablement. Total disablement, how the amount of the compensation can be determined. So we would be using the schedule 1 for this, because into which this schedule has been divided. A total disablement, into which we are saying where the loss of the earning capacity has become 100 or the person has become incapacitated. Now the person cannot do any other kind of the work. That's why the amount of the compensation can be given on that basis. So we are having the temporary disablement, and when we talk about the temporary disablement, again that has been divided into the permanent disablement and the partial disablement. That this temporary disablement, again there can be the injury. Say for example, the list of the injury has been cited there. Say for example, when we say the loss of index finger, loss of a thumb, so like injury has been indicated. So the amount, the percentage of the injury has been indicated into this schedule. So this is very, very helpful, because on that basis we say that is how much the amount of the compensation to be given. After that, we are having into the schedule 2 list of the persons who are subject to the provision of section 2 clause 1. They are included into the definition of the employee. Now this definition of the employee has been broadened. Third schedule talks about the list of the occupational disease. Now after making the amendment under this act, the occupation disease has been included, and if any of the employee get the contamination of these kind of the disease, we are treating these disease, occupation disease, like an injury has been happened to the person, and because of this the person, now the work efficiency has been reduced. So we are having this so the benefit can be given to the worker. That's why the occupation disease has been included. And schedule 4 talks about factors for which working out lump sum equivalent to the compensation amount in case of the permanent disablement and death. So into which we are talking about, that is in case of the death. So we are having this thing has been given in section 4. We are saying if the person dies, then in that case the total amount of the compensation has been fixed. That is, say in case of the death, now 1,20,000 has been fixed. Or otherwise we are having, that is the age of the person will take into the consideration, and the wages or the person would be taken into the consideration, and that would be multiplied by the relevant factors. So we'll talk about this thing later. So that's why this schedule is very, very important for determining the amount of the compensation. We are having the doctrine of added peril, and we are having the contributory negligence and the voluntary non-fit injuria terms. So here when we talk about the doctrine of the added peril, so because this doctrine talks about if a workman while performing in a duty does something which is not required to do so, but he involves extra danger, the employer won't be liable to pay the compensation if any kind of the injury has happened to him. Or if we are talking about either it is a case of the voluntary non-fit injuria, the person is ready to take the himself, and but it was not required. But then in that case, or either we are talking about the contributory negligence. So all the defenses they are given into the law of torts. So for this the employer won't be liable. So here we are having the doctrine of notional extension. So other than the employment, so this doctrine has been came with this intention is if the someone is, so we can give the benefit of the work, we can give the benefit of the place to the employee, either the person had died or the injured one. So the benefit can be given to the person. Say for example, if the someone is doing the work into the any of the establishment and going back, so when the person is going back to the home, if something has happened to the person, so the benefit can be given to the person. It is not necessary this kind of the benefit would be restricted to this establishment only. So either the person is going home or coming from the home, so the person would be getting the benefit. Or sometimes what happened, if the person is say for example going for the office work to any of the destinations, say for example just to collect the tax, then in that case if something has happened, accident has happened, or say for example, if any of the person attacked on that fellow, not to give this kind of the due amount to this officer. So if someone is discharging the duties relating with the establishment, then in that case we can say the benefit has to be given. So into the doctrine of notional extension, we are covering the benefit which has been, if any kind of the injury has happened in the course of employment or out of course of employment. So this kind of the benefit has to be given if the person is discharging the duty during the course of employment to the deceased one or to the injured one or to the employee. So when we talk about scope and coverage of this act applies to the persons who are covered under Schedule 2. So the definition of the employee has been given in Schedule 2. So they are included. It would be applicable upon the factories, mines, plantation, major ports and docks, mechanical propelled vehicles, construction works, newspaper establishments and certain other hazardous occupations other than those employed in a clerical capacity. Into this, this act won't be applicable because the schedule has expressly excluded, like they won't be coming under the where this employee compensation act will not be applicable. Members of the armed forces of the union, employees covered by the ESI Act 1948, say for example, if someone has been covered by the Employee State Insurance Act, so the person cannot take the double benefit. So the person can't get the benefit here if the employee is getting the benefit under the ESI Act. And a dependence benefit available, casual workers, they won't be covered. Workers employed otherwise than for the employer's trade or the business, so they won't be getting the benefit under the scope of this act. Now we will cover the important definitions here under this act. We are having the important definition we have taken. Say for example, our definition of the commissioner. If we are talking about whom we would be saying the commissioner, the definition of the commissioner has been given. It has been defined, otherwise it has been defined in section 20 when we talk about how the appointment of the commissioner can be made. So under this act, the commissioner would be the person who is doing the work relating with the Workmen Compensation Act only, and the definition has been given in section 2 clause 1 clause B. So here when we are talking about, that is how the appointment of the commissioner can be made. Here the state government may by notification in official gazette appoint any person to be the commissioner for the workmen compensation for such an area, and which has been specified into the notification, and any commissioner may for the purpose of deciding the matter refer to him for decision under this act choose one or more person possessing special knowledge of any matter relevant to the matter under inquiry or assist him or in holding inquiries. So who would be appointing, because the state government, they would be appointing the commissioner, and the commissioner is, if the commissioner wants to seek the help, so he can take the help from the two or more persons, he can take the assistance. And where sometimes what happen, if the government, they have appointed more than one commissioner, then in that case the area has to be determined, the area has to be, they must have to give the proper jurisdiction. So the commissioner had been appointed for any area, the state government can can issue an order, it can be general or the special order, and regulate the distribution of the business between them, if they are having more than one commissioner. Any commissioner may for the purpose of deciding any matter which has been referred to him to decide the matter under this act, choose one or the more other persons who are having the special knowledge of any matter relevant to the matter under inquiry to assist him. So he can seek the help the person who are having the knowledge into that particular. Say for example, if the commission wants to seek the help from the law people, he can take the help. The commission needs the help from the medical people. Again, he can assist the medical people for making the inquiry. And every commissioner shall be deemed to be the public servant within the meaning of the Indian Penal Code. So the commissioner would be treated to be the public servant under the section 21 of the Indian Penal Code. And now this Indian Penal Code has been amended now, and now this is the Bharatiya Nyaya Sanhita 2023. So would be the public servant under this. So if we are talking about eligibility of the commissioner is, so commissioner should have the a minimum experience of the 5 years in state judicial services, or we can take the commissioner, like commissioner can be the advocate or the pleader, but should have the minimum experience of the 5 years, or commissioner can be the gazetted officer but should have the experience of the 5 years. So we can take he should have the experience of the person management, HR, like human resource management. The person can be the appointed to be the commissioner. Next definition is employer, and the employer has been defined in section 2 clause 1 clause E, and it includes anybody or persons, whether incorporated or not, any managing agent or employer, and any legal representative of the deceased employer, any workman whose services are let on hire to another person by the person with whom the workman has entered into the contract of service or apprenticeship, means any such person while the workman is working for him. So the contractor even falls into the definition of the employer. So there can be the legal representative, but if someone is, for example, the legal representative can be employer, but if someone is, the managing agent, the person cannot be, the employer. So this is very, very important that the person should have the same position. When we are talking about definition of the employee, it has been given in section 2 clause L, clause N. So now, after making the amendment into 2010, the definition of the employee has been, the broadened. So ambit has been wider now. So these persons are included under the definition of the employee. A railway servant would be coming under the definition of the employee. A master, seaman, or any other person of a crew of a ship. A captain or other person of a crew of a aircraft, a person recruited as a driver, helper, mechanic, cleaner, or in any other capacity in connection with the motor vehicle, a person recruited for the work abroad by a company, that is the person has been employed outside India, and which has been specified in schedule 2, and employed in such a capacity which has been specified in schedule 2 of the employee compensation. These persons, they would be coming under the definition of the employee. After that, we are having the definition of the dependent. See, this is very, very important definition when we talk about the definition of the dependent, because normally here we are not making the classification like who would be coming under the priority, who would be, who can claim. But when we talk about sometime what happened after the death of the deceased, normally the battle comes between the dependent, who everyone start to claims. So for this, the criteria has been developed, and we are having the that has been divided accordingly, so the dispute can be avoided. So definition of the dependent means any of the following relatives of the deceased employee, namely, first is a widow, minor son. First is widow. A minor son can be legitimate or adopted. A unmarried daughter can be legitimate or adopted, or widowed mother. So these four persons would be coming under the first, this thing. And if sometime what happened, if wholly dependent on the earning of the employee at the time of the death, a son or a daughter who has attained the age of 18 years and who is infirm, then in that case, they would be entitled to get the compensation. Into this second category, say for example, the deceased had son and daughter. They have attained both the girl and the boy, they have attained the age of 18. But they were totally dependent upon the earning of the deceased, because they can't do the work due to the infirmity, because they cannot, they are not in a position to earn. So that's why they would be here they would be dependent upon the earning of the deceased. See, on the other hand, under the Employee State Insurance Act, we are having the ground, but the person who would be getting the benefit, that would be, the age has to be 25 years. So, but here we are talking about, that is, the person has a son or the daughter, they have attained the age of 18 years. The third category is, this is a very lengthy one, if wholly or part, they were dependent on the earning of the employee at the time of his death, into which the list is very, very long. Here, a widower. Widower means a very simple thing. A wife is not into existence, wife has died. So this person is the male person would be entitled. A wife is not there, that's why the person would be entitled. So say for example, if the wife was working, then in that case, if the wife is no more, then in that case, the husband, this widower would be entitled to get this benefit. A parent other than the widowed mother, it means the father would be entitled, a minor legitimate son, an unmarried illegitimate daughter, or a daughter which is legitimate, illegitimate or adopted. If married, then in that case, and a minor. If widowed and a minor. So in that case, a minor illegitimate son would be entitled, unmarried illegitimate daughter would be entitled, daughter either legitimate or illegitimate or adopted. If married but minor, or widowed and a minor, they would be entitled. A minor brother would be entitled, or an unmarried sister would be entitled, a widowed sister if minor. A widowed daughter-in-law would be entitled, a minor child of a predeceased son. Now the person minor son of a predeceased son. So in that case, because now the son is not into the no more, that's why the child of the son, so now the person would be entitled to get the benefit under this act. Grandson, a minor child of a predeceased daughter, when no parent of the child is alive, then in that case, a minor child of a predeceased daughter, and so now the daughter is not there and her husband is not there, then in that case, this child would be entitled to get the benefit. Paternal grandfather, if no parent of the employee is alive. So we are having the long list where we can say that's why the coverage has been given. So benefit can be given it to the this person, and here the person who even we have given the coverage to the apprenticeship, because under the Apprenticeship Act, here the compensation can be given to the apprenticeship, the person who is doing the training. So he would be entitled if the person gets the personal injury caused to him by the accident and out of course of employment. Next definition is disablement. Disablement. This disablement word has not been defined, but here into the schedule, that is we are talking about, that is total disablement and the partial disablement has been given. If we are saying this is a case of the total disablement, it means now the loss of earning capacity has become 100%, and now the person has become incapacitated. Now the person cannot do any other kind of the job. When we talk about this schedule, that is schedule 1, so the list has been given, that is who would be coming under the category of the total disablement. See for example, if the person lost both the hands, amputation of both the hands, so we can say the loss of earning capacity is 100. Loss of eyes, loss of earning capacity would be 100. So the injury has been indicated into this schedule, and the part 1 is very clear where because they have been included under that schedule into the part A, and that's why they would be getting the benefit of the total disablement. That has been given in section 2 clause L. Partial disablement, section 2G talks about partial disablement. It means we are saying this kind of the disablement because of which it has reduces the earning capacity of the employee in any establishment into which he was engaged at the time of the accident, and resulting into the disablement. Where the disablement is of a permanent nature, such disablement reduces his earning capacity in every employment, and he was capable of undertaking at that time. So when we talk about partial disablement, so for this they have been given in schedule 1 and part 2. It talks about that is the partial disablement. One more definition I am taking it here, that is the definition of the wages which has been given in section 2 clause M, because into the wages we are saying privileges and the benefit can determine in money, but it does not include these things will not be the part of the wages. Say traveling allowances, it is not the part of the wages. Value of any traveling concession, any kind of the discount which has been given for the traveling, it is not the part of the wages. Contribution paid by the employer for employee either for the PF or pension, it will not be covered. Special expenses, that is not the part of the wages. So this kind of the things will not be the part of the wages. Now we are talking about chapter 2, employer's liability to give the compensation. So it has been mentioned from section 3 to 18A, and into which when the employers would be liable to pay the compensation, then in that case it is very necessary that the employer would be liable to give the compensation either in case of the death, the person would be, of course there is no dispute, the person would be giving the compensation to the deceased, and after death of the deceased, the dependent can take the benefit. And when we talk about, if the, say for example, but it is very necessary that if personal, general rule is, if personal injury is caused to the employee by the accident arising out of and in the course of the employment, the employer shall be liable to pay the compensation. So, but it is very necessary that there should be the personal injury has to be there. Into this act, this term has personal injury has not been defined. And when we talk about to include, say for example, nowadays we are talking about personal injury, it doesn't mean the only the physical injury, we are including the disease or the occupational disease into the category of the personal injury. And the second point is, there should be the accident, because the person has suffered from the accident, and again the accident has not been defined here under this act, so it has been given into the definition. So that is accident. What accident is, that is an unexpected event happening even though there has been no negligence on the part of the workman. And the third is, it is very necessary that this kind of the injury has been caused to the person in the course of employment and out of course of employment, and this injury has to be not less than 3 days. To get the benefit under section 3, it is very necessary that there must be the causal relation or the connection between the injury and the employment. So when we talk about when the employer will not be liable under this act, because if say for example, in respect to the injury which does not result in a total or the partial disablement of the workman for a period exceeding 3 days. So if the injury is lesser than the 3 days, then the employer will not be liable. In respect to the injury not resulting in a death and caused by the accident due to the influence of the drinks or drugs. So if the person has consumed, if employee has consumed the drinks or the drugs, or sometime if it is a case of the willful disobeyed order or disregard of the safeguards. So if the employer is saying to use the safety measures, but the person is not ready to listen anything and making the disobedience and not using the safeguards, and sometimes willful removal or disregard by the workmen of any safety guards, then in that case, if the person is removing the safety devices and willfully removing these kind of things or this kind of the devices, then in that case we can say that this is not the job of the employer to give the compensation. So for example, sometime what happened, if any of the employees going into the chemical factory and it is full of toxins and the advisory has been given, this is one of the mandatory condition to wear the mask, but if the employee is not bothering, say for example, willfully removing the mask, then in that case the employer will not be liable for this kind of the injury. The employer shall not be liable to pay the compensation to the workman in respect of the disease. So unless the disease is directly attributable to the specific injury by the accident and which has been arisen in the course and out of course of employment. Now come to the occupation disease. So because nowadays the occupation disease would be considered to be the injury by the accident. So here we are having the long list has been given for the occupation disease. If the person if any of the employee just because of the contamination at that point, or later on if this kind of the injury directly attributable to this kind of the suffering, then in that case this employee would be entitled to take the compensation from the employer. So it is very, very necessary that these kind of the workers employed in certain occupations, they are exposed to certain disease and into those occupations. So into Schedule 3, the long list has been there. Say sometime we says infection due to the contamination or infrared radiation, skin disease, because they are doing the work into the chemical leather industry processing units. Sometime hearing impairment caused due to the noise, lung cancer that has been due to the dust, or disease due to the effect of the heat and the cold and extreme hot or extreme cold climate. So if any of the employee get these kind of the disease which has been cited into the Schedule 3, then in that case it will consider deemed an accident, so they would be getting the benefit. And sometime what happened, because when we talk about Schedule 3, we are having this disease, this occupation disease, they are divided into Part A, B and C. So when we are talking about Part A, and any of the employee get the occupation disease, no minimum service, no time limit has been required. So the person would be entitled to get the benefit. But in Part B, any of the employees doing into the continuous service of 6 months would be entitled to get the benefit. And Part C, service for a period specified the central government, then in that case the person would be entitled to get the benefit if the person has done the work for a particular period. And sometime what happened, the government, they can notify any kind of the occupation disease, they can add any kind of the disease into the occupation disease. So if the government feels so by after giving the notification in advance for 3 months, so state government they can add. And when we talk about this kind of the disease, sometimes the employee get these kind of the disease after the employment. So but if it was related with the employment, then in that case the compensation can be given it to this person. Section 3 clause 2A, it talks about multiple employers. Say if the employee does more than one employer, then in that case who would be responsible? This kind of the responsibility would be shared, and the person would be, employer would be liable proportionately. That would be decided by the commissioner. So but it is very, very necessary that this kind of the disease has to happen in the course of the employment only. And when we talk about, and if any of the employee has done the work with under Part C only, and with the one or more employer, so both of them they would be liable according to the proportion. So after that, no compensation, Section 3 clause 4, it says that, and yes, Section 3 clause 3, it says that any state government or the central government, they can add the employment or the disease to Schedule 3 by notification and after giving the notice in advance for the 3 months. Section 3 clause 4, it talks about no compensation for any kind of the disease unless directly attributable to a specific injury by the accident. So if this kind of the disease is relatable to the employment, then in that case the benefit can be given, otherwise not. Say for example, if someone was doing the work into the welding factory and got the cataract, get this kind of the eyes problem, then in that case the person would be getting the benefit because they are the direct connection is here. That's why the employer cannot ignore. And bar on suit, Section 3 clause 5 says that no compensation if the civil suit for the damages has been instituted, and no civil suit maintainable if claim has been filed before the commissioner. So compensation agreement made under this act. So it is very important that because these are the civil laws, if the person is getting the benefit under the Workmen Compensation Act, we are having the commissioner who would be dealing with all these things. But if the person has filed a civil suit again, so he won't be getting the benefit under the civil law because already the thing has been taken up. So that's why the person cannot take the benefit from the two places. And sometime what happens if the agreement between the party employer and the employee, then this kind of the agreement can be enforceable. They can decide it and with the help of the commissioner. Now we'll talk about section 4, amount of compensation. This is very, very important. So here we are saying how much the amount of the compensation can be decided. For this we are having in section 4 clause 1. So we are saying that is a compensation for the injury. So we are having the different grounds for this. How the compensation can be given, how much the compensation can be awarded. So in case of the death of the deceased, then in that case the 50% of the monthly wages can be given. So, and that has to be multiplied by the relevant factor. This is the one criteria, and the amount has been fixed. That is 1,20,000, whichever is high. Because see, in 2020 amendment has been made. That is the wages. It has been laid down that wages cannot be reduced than the 15,000. So we are saying that someone had died, then how we would be deciding the compensation? For this, the 50% of the wages. So 50% of the wages would be 7,500. So these 7,500 had to be multiplied by the relevant factor. When we talk about the relevant factor, it has been given into the schedule 4, into which the 2 points has been given, because the age of the employee has been cited, and it starts from 16 years up to 65 years. On the other hand, that is relevant factor has been cited. So when we talk about, say for example, if the employee is having less age, say for example, when we say 20 years, so if the person died, then in that case, the relevant factor which has been indicated here, just for this age group, that would be high. Because this is the young man, that's why the amount of the compensation would be more. But on the other hand, when we talk about the person who is having the 60 years of age died, then the relevant factor would be less. So, amount of compensation in case of the death, so 50% of the wages, so 7,500 is the minimum wages, and it has to be multiplied by the relevant factor. So we can get the amount of the compensation. On the other hand, the amount has been fixed by the statute, that is a 1,20,000. So whichever is high, this amount can be given. So after that, permanent total disablement. So again, for the permanent total disablement, we are having this amount is 60%. 60%, say for example, the minimum, the wages has been fixed, that is 10,000. So 60% would be, that would be 6,000. It has to be multiplied. In case of the death, the amount was 50%, but here we are saying 60% because the person is surviving, and if the person is surviving, he is having the expenses, medical, food, multiple things he has to take care and manage. So that's why this amount of the compensation is 60%. So the formula is the same. Again, we'll see what is the age of the employee, and not age of the employee means we'll see how much the age has been completed. So into schedule 4, the age is, we are saying the person has completed this age on last birthday. So we'll see the age, and in front of the age we'll see the relevant factor. So we will multiply according to the the 60% by the this relevant factor. We'll see the age, and accordingly, because the 4th schedule is very, very relevant, into which because the age has been indicated. So we can get we will come to know how much the amount of the compensation would be given into in case of the total disablement, in case of the death of the person. Say for example, permanent partial disablement. So we are having this kind of thing. So on that basis, we can say for example, if the permanent total disablement, so the person has become permanently total disabled, we are saying the person has become incapacitated, he can't do any kind of the work, the loss of earning capacity is 100, but if the person is survive, how the person would be maintaining. So again, the formula would be same. For permanent total disablement, it is not necessary the person would be into the schedule 1 and it has to come into the part 1. Sometimes the injury has to be 100%. So for example, if the injury is 40% plus 40% plus 30% plus 20%, it means the total should not to be the more than, he cannot get the benefit of more than the 100%. So we'll make if the person is having the multiple injury, we'll make the aggregate of that, and accordingly we'll give the compensation. But it cannot be given the more than the 100%. A temporary disablement, it can be total or it can be partial. Then in that case, here we will give the half monthly payment. So if we are talking about half monthly payment, means this payment would be given on the 16th day from the date of the disablement. And so accordingly we'll make the payment, and after 15 days of the payment, again the payment would be given, so payment would be given on the 16th day. So the wages would be given on a 16th day, and accordingly we can decide so how much the compensation. And sometimes what happen, if the injury or the accident has happened outside India, then in that case the compensation, and say for example, if the person was doing the work outside India, US, UK or in any other country, and already the compensation has been given, so that proportion would be reduced into the from the Employee Compensation Act, that would be adjusted. Section 4 clause 2, it talks about half monthly payments that would be given on the 16th day, and so accordingly we give this kind of the compensation. And say if some kind of the injury has happened, due to the injury the death has happened, then in that case for the funeral expenses this amount can be given, and it can be adjusted later on, and it can be given to the eldest surviving member of the family. And now through the amendment this amount has been increased, it's a 5,000 now. Okay. Section 4, it talks about compensation to be paid when due and a penalty for the default. So it is the duty of the person is employer, they must have to make the payment, they must have to give the compensation when it is due. If the person fails, then in that case the person can be liable. Sometimes what happens, if the liability is disputed, then if the employer is not ready to take the responsibility, don't accept, then in that case the provisional payment can be made by the employer, and the person would be making the deposit of this amount to the commissioner, and the commissioner would be making the payment. But later on the employee can claim the full compensation later. Section 4A clause 3 says default in payment. If the person is getting failed to make the payment, then in that case employer the penalty can be imposed upon the person. The employer would be paying the interest, that is a 12%. It's a very simple interest, but for this it can be increased, so normally the central government, they fix these kind of things. And if you find that there is no valid reason for the making the delay for making the payment, the employer may be directed to make the penalty up to the 50% of the areas. So, but yes, of course, we will follow the principle of natural justice. So, for imposing the penalty, the opportunity of being heard has to be given. Because this kind of the interest, when we decide for the interest, so for this we are having the scheduled bank, we will refer the scheduled bank, how much the scheduled bank is lending the rate of the interest. We can see that this scheduled bank, they are listed into the second schedule of the Reserve Bank of India Act 1934. And now the question comes for the distribution. So this is the duty of the commissioner. They would be making the distribution to the dependent. And after that we are talking about method of calculating the wages. So in section 5, so we'll see the monthly wages, and we'll see that how we'll decide the wages. So first is, because into the other countries we see that the monthly wages can be given on a monthly basis, weekly basis, daily wages, or a piece rate basis. But India, normally we are having the practice of the monthly wages. And if any of the employee has served continuously for the 12 months or more, then in that case, before the accident, we will give the wages accordingly. So we'll see the total wages in last 12 months and we'll take the average of it. So accordingly we'll give the wages. But if someone has served less than the 1 month, it's very tough to decide, then in that case, before the accident, then how we decide the average monthly wages, what can be done? So another employee can be referred. I mean, the person who is having the similar kind of the same work. So with the employer, we can take the idea. And if we find no one, then in that case, another employee who is doing the similar work into the same locality. So on that basis, we can calculate the wages. And in other cases, Say for example, if we are not having this kind of the data is not there and not available this kind of the information, then in that case the number of days that would be this number of the days 30 monthly would be multiplied by the total wages. So and accordingly the number of the days the person has done the work would be divided accordingly. So we can get this thing, and it is very necessary for giving the wages is continuous service has to be there. So whom we would be saying the continuous service for this for the purpose of this act is, it is clearly mentioned that the person who has not not interrupted or absence from the duty not more than 14 days, then in that case the service of this person will not consider to be the that is a interrupted services. But if the person is say for example absent, if the person is absent more than 14 days, then this kind of the it will not be considered to be the continuous service. So it has to be lesser than the 14 days to decide the wages. After that, review, because once the amount of the compensation has been given, it's with the commissioner. So if it has been given in case of the temporary disablement cases, the commissioner they can mutually they can make an agreement, or by the order of the commissioner it can be reviewed by the commissioner on an application given by the either the application has been given by the employer, employee, or into this application it has to be the certificate has to be given from a medical practitioner stating that now the circumstances has been changed, now the condition is not the same. So accordingly this kind of the thing can be reviewed. Sometimes what happened, the person is, if the commissioner is okay, satisfied, now the circumstances has been changed, the person this employee has recovered, then they can reduce the amount. But sometimes they feel so the situation is this kind of the injury has been aggravated, then in that case the amount can be increased. But sometimes what happen, if the duty has been imposed upon the if the employee is saying just come for the test, take this go for the take this kind of precautions, so this kind of the injury should not be aggravated, but the employee is not bothered, he doesn't listen, and the employee and this kind of the injuries get aggravated, then in that case the person, this kind of the amount can be increased. So for section 7 talks about computation of half monthly payments. So sometime lump sum can be given. After that, section 8 is very important. It talks about the distribution of the compensation. So who would be entitled to take the compensation is, so employer can direct payment directly to the dependents in case of the death, and so the person would be giving the 3 months salary to the deceased persons. So sometime what happen, the employer can adjust these kind of the amount later on, but he would be depositing this amount with the commissioner, and the commissioner shall call all the dependents of the deceased and determine the method of the distribution of the compensation. And but if no dependent found, then in that case this amount can be refunded back to the employer. And so sometime what happen, if the request has been made by the employer, the commissioner can furnish the details for the, on a request by the employer, the commissioner shall furnish the details of the disbursement. So if they are talking about these things, but sometime what happen, because if the half monthly payment they are giving, then in that case the commissioner can make the direct payment to a person, but not to the woman directly. They want to be, the commissioner is not, cannot give the payment directly to the woman and to the person with a disability. So of course this is not suitable when we talk about this kind of things, but this is the provision. And so even sometime what happen, if the commissioner feels so this is not valid, so this kind of the commissioner can vary this kind of the order. He feels so the dependent has not taking care of the children and change into the circumstances has been now this informed person is fit, and sometime realize the fraud has been done, so the commissioner is entitled to recover back. Section 9 talks about compensation note to be assigned or attached. So for this employee, so this kind of the liability cannot be attached. And after that, notice and the claim. Section 10 talks about To claim the compensation, the claimant shall give a notice of the accident to whom? To the employer, by entering into the notice book within a reasonable time, and every such notice shall give the name and the address of the person who has been injured. So this is the duty of the employer. So this employer, they must have to bring it to the knowledge of the authority, and into this notice they will mention the name of the person, the address of the person who has been injured or the death has been caused, and they will talk about what kind of injury has been made. So they can claim the application to the commissioner within 2 years of the date of the accident. In case of the occupation disease, again they will, what kind of disease has happened, and so they would be deciding that this kind of the period will count when the person starts absent from the work continuously, and so accordingly they will make the payment. And so sometime what happen, if they feel so there is a defect into the notice and not properly notice has been given, so it will not bar the claim of the compensation. So after that, power to require from the employer's treatment regarding the fatal accident in case of the serious injury has happened. This is the duty of the employer, they must have to take care. And if the employer is of opinion, they will make the inquiry and accordingly and report of the fatal accident and the serious injury. So this is the duty of the person is, if it is a case of the serious injury, they will inform the employer. And so sometimes the state government, even they can expand the other industry into this. So they must have to report for the this kind of the fatal injury or serious injuries within 7 days to the commissioner. After that, medical examination, already I mentioned that is mandatory. They must have to comply with the instructions of the employer. And contracting, if we are talking about contracting, so liability of the principal employer, and directly this is general rule, the principal contracts, because that is like principal shall be indemnified from the even contractor if the payment has been made by the principal in that case. Then section 13 to 16. Section 17 is talking about contracting out of the compensation. So no agreement of the contract can be creating where this employer is relinquishes this kind of the liability. He cannot waive off this kind of the agreement. So section 19 talks about the reference to the commissioner. Already we have done that because the commissioner is an authority here. So this kind of the they can refer the cases to the commissioner, and if the question arises that in any of the proceeding under this act as to the liability of the person to pay the compensation, who is liable, including the question is whether a person injured is a employee workman or not, how much the amount of the compensation would to be given, the duration of the compensation, including all these questions, and to what extent this liability is, extent of the disablement. This kind of the question can be taken up by the commissioner, and in default of the agreement, so again this can be settled by the commissioner, and no civil court or having the jurisdiction to decide the matter, because already we have discussed that. Because and after that, venue of the proceedings and the transfer. So for this, where the accident has took place, or in case of the death of the employee or the defendant resides, where the employer registered office, they can start with the proceedings, and they must have to give the application into which concise statement, relief for the claim, for the compensation, and the notice has to be given. So power of the commissioner is to, they will make the require the other deposit in case of the fatal accidents. If they are not having the sufficient amount, then they can give the order, and they can take an action. Power of the procedure of the commissioner is, civil court power has been given it to the commissioner is, and he can direct the applicant or the authorize any of the person like inspector, legal practitioner, commissioner. So they can and on that these persons they can be appointed, and so ultimately the power has been given to the commissioner. If the commissioner feels so, the appearance of the party, and for your better understanding, the schedules has been given here into this, because we are having the Employee Compensation Act, into which all the procedure has been given. So everything has been given, so we'll go according to the Employee Compensation Act. Jurisdiction, procedure, and everything has been discussed here under the Employee Compensation Act. And so all the proceedings will be going according to the Employee Compensation Act 1923. So for the better understanding, all the schedule has been cited here, and the detailed schedule has been given. So this is from my side. Thank you so much.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. I'm here to tell you a little bit about how we can think about globalization in a sociological manner. Now, one of the important concepts in the field of globalization, and particularly global studies, is that of global flows. It's a term that was developed by the sociologist and anthropologist Arjun Appadurai. He said that as the world is becoming a more and more global place, you increasingly see the movement of different types of things, uh, both tangible and non tangible, across multiple national borders. Um, to begin with, you can look at how your day proceeds. I often need a cup of tea to actually start my day. Now, if you think about it, tea that we drink is not something that is that originated in India. It's actually a drink that comes to us from quite far away in China. And this is something that has happened not immediately, but it has happened 400 or 500 years ago. Um, so this kind of movement actually happened with the movement of people. Now, this kind of movement of people and goods is one category of flows that Appadurai talks about. A second category of flows could be financial flows. Uh, and a good way to think about this is the kind of volatility that you can see in economic markets today. For instance, in 2008, the whole world experienced a very serious economic jolt. Um, Developments in the country of Iceland had a huge repercussion across many, many countries in the world. Now, that gives you an indication of the kind of financial flows that are a part of globalization. So, we're not only talking about money flowing from place to place, but also financial decisions made in one place having an impact on other parts of the world. Appadurai also argues that there is a third category of flows, which he refers to as the flow of images or media. Now, this is something that I'm sure you're quite used to. Much of the programming that you watch on television today, for instance, you may actually be watching channels that have originated or programming that's originated elsewhere. More than that, it could also be that the programming that you see today is influenced by shows that have originated abroad. Similarly, you can have content that was made in India, which makes its way to other places in the world. For instance, we know that Bollywood films are extremely popular in many countries across Africa. So this kind of movement of media is, Appadurai considers it to be an important part of globalization. The fourth category that he talks about is the movement of ideas. So this means that ideas that are popular in one part of the world are not restricted to that part alone, but they actually travel across borders. So, for instance, something that you may read about in the papers would be, say, events such as gay pride events. Now, gay pride events have their origin in places like New York. But the idea that there should be equality between people, irrespective of what their sexual preference is, that is an idea that has now become popular across the world. And so that's the fourth category of flows that he referred to. The fifth category of flows that Appadurai talks about is that of technology. An easy way to think about this is, let's say tomorrow there is news announced that Apple is going to release iPhone 7. As you can anticipate, there is going to be a lot of excitement in many parts of the world, and people are going to start queuing up, waiting for those products to actually come to their country. So, technology is something that is quite exciting and really moves across various national borders.